writ of mandamus compels a public official to perform a public duty. In this case, Ned's transfer to a regional processing country, Nauru, as soon as practicable. It is an obligation under the admittedly completely fucked Immigration Act. As the judge noted, the time frame as soon as practicable may be debatable, except our own PM, when Immigration Minister back in 2013, proudly declared that their target for reasonably practicable was 48 hours. Judge Rangia, in his findings, noted that the 8.5-year delay for what ScoMo believes should be accomplished in 48 hours was a delay of magnitude, which called for an explanation. The evidence in that case was damning. There were no steps being taken to explore transfer to Nauru, only forced repatriation back to Iran, something that was never going to be successful as Iran was refusing forced transfers. They offered no evidence as to why they couldn't take Ned back to Nauru, despite this being the focus of an expensive court proceedings. As the judge noted, their only explanation was the government did not believe that the obligations under the Act applied to them. Essentially, they did not believe that they had to comply with their own legislation. They were above the law, seemed to be their case. Judge Rangia made clear that the legal obligation that Ned sought to prove did exist, and the government had offered no credible evidence that they were exempt. The second element was about what was fair and just while Ned was being held waiting transfer to Nauru. And in these circumstances, Ned's lawyers offered a number of different scenarios of community detention, including with friends back in Brisbane and also in a 6-bedroom house in Western Australia.